Honourable Susan Carter.
Thank you, Mr Deputy President. I rise on behalf of the opposition in relation to the Children Criminal Proceedings and Young Offenders Legislation Amendment Bill. We witnessed a tragedy yesterday. A 15-year-old boy stabbing another boy to death in suburban Sydney. No one's life will ever be the same again. In Kempsey earlier this month, 3 young males broke into Sue's home, stood over her as she lay in bed and swung at her with a machete. Sue said if she hadn't moved quickly, she would likely be dead too. Disturbingly, she said of the knife wielders, they would not have been any older than 13. In Walgett, a couple of weeks ago, a 14-year-old boy and a 15-year-old boy were arrested for an alleged attempted break and enter, using screwdrivers to try and force the door of a home. All this in just the past few weeks. Youth crime is an urgent problem which must be addressed. We need action, and we need this for the young offenders as much as for improved community safety. There are voices who say it is wrong to treat young offenders as criminals. Well, it is criminal to not hold young offenders accountable for their actions and clearly demonstrate that there are consequences, often significant, for what they do. Every parent understands this. Sue in Kempsey understands this. The machete marks are still scarring her fridge, reminding her several times a day of her ordeal. A short, sharp shock early on can divert from more serious criminal activity, and this is a good outcome for everyone. But this is not the way in which our criminal justice system is currently working. We know too well the revolving door of bail courts and youth justice, which doesn't deter and often leads to an escalation in crime. We welcome action on the common law doctrine of doli inca pax, which loosely translated from the Latin means that the sweet young child is incapable of knowing right from wrong and therefore cannot be held criminally responsible because they cannot satisfy the mens rea or the mental element of a criminal offence. This doctrine has been acknowledged as a major reason why many child offenders are not facing appropriate consequences for their actions. We welcome the government bringing this bill to the House, but like much government action in relation to crime, it is a quick fix designed to look good, but simply does not properly address the issue. The government's bill is not the solution to this crisis. All the New South Wales government's bill does is, in effect, is to enshrine the existing principle of doli inca pax into legislation. By doing this, the government actually ensures that doli will continue to be a way for serious young offenders to avoid accountability. This helps no one. Doli inca pax will remain a subjective test, asking us to look into the mind of the young offender and by inference try and establish their level of understanding and hence culpability. The result in New South Wales will be continued inconsistency, more appeals and uncertainty for police and victims, and more tragedies such as that we witnessed overnight, which effectively means 2 young lives lost, one to murder, the other to the prison system. That we need action on doli inca pax is clear. Since the 2016 High Court decision in RP and the Queen, conviction rates for young offenders in New South Wales have dropped by 60%. In Victoria, over the same period, the conviction rate has dropped by a staggering 70%, from a 77% conviction rate to only 7% today. So it is very surprising to us that the government's bill essentially adopts the Victorian position, a place which some have labelled the machete capital of Australia. This approach will do little to help make women like Sue feel safe in their own homes. Our position, and one which we will seek to achieve by amending this bill, is that we should adopt the Queensland position. Queensland has an objective test, which has seen over the same period when our conviction rate has dropped by 60% and Victoria's by 70%, a mere 5% reduction in convictions for youth crime. The Queensland test has been in place since 1899. It is tested, effective and proven. There is more than a century of jurisprudence explaining how this law works, and therefore it will be able to be used effectively by the courts. This is in stark contrast to some of this government's novel legal experiments, such as the entirely new test contained in Section 22C of the Bail Act, which at least 3 justices of the Supreme Court have criticised as legislating for a test which is unknown to the law, and consequently will take an extended period before it has been tested and will operate with certainty for the benefit of the entire community. The Queensland approach, mirrored in the amendment that we will move, was supported by the New South Wales Police Force and the Police Association in submissions to the recent inquiry into Dolly Incapax. Our police are at the forefront of maintaining order, and we are happy to take their advice. We support the approach which they recommend. Our amendment is simple. It sets objective, practical criteria for determining whether a young person had the capacity to understand right from wrong at the time of the offence. The government's bill, by contrast, ensures that the common law doctrine of Dolly Incapax will be put in legislation and will remain what some have described as a lawyer's picnic, with, we fear, no change for the safety of the community. Our amendment encourages accountability and will ensure that there are consequences for serious criminal behaviour. And this helps offenders as well as victims and potential victims of crime. The opposition amendment allows the presumption to be rebutted through demonstrated behaviours, not like the government's, to meet technical legal burdens. As an example of the difference between the two approaches, consider a young offender who has been before the courts on some 20 occasions. The government approach will require a subjective consideration of the actual understanding of the young offender in relation to his or her 21st offence. The fact that there have been 20 prior offences will continue to be of little relevance. The question will remain to be decided subjectively and inferentially what was the level of understanding of the young person on the occasion of the 21st offence being considered by the courts. The government's bill does legislate matters to which a court must have regard, but these focus on the offence before the courts and the circumstances surrounding the commission of the particular offence. It enshrines the test in RP and the Queen, which Boxar has identified as creating many of the challenges which this legislation is meant to address. The Attorney-General, in his second reading speech in the other place, made it clear that the codified test in this bill is, quote, intended to reflect the statement of the High Court in RP and the Queen that no matter how obviously wrong the act or acts constituting the offence may be, the presumption cannot be rebutted merely as an inference from the doing of that act or those acts. The Attorney-General then goes on to give the following example, quote, in other words, the bare facts necessary to satisfy the elements of the offence will not, on their own, be sufficient to rebut the presumption. For example, proof that a 10-year-old child hit a household member would not be of itself enough to prove that the child knew it was seriously wrong to do so, no matter how objectively wrong that act is, end quote. If our test is in place, however, the question of understanding will be decided objectively. Would the reasonable 13-year-old, having already been before the courts 20 times, understand that they were engaged in criminal wrongdoing on this occasion? Or, applying our test to the Attorney-General's example, objectively, would a 10-year-old child who had hit a household member on 20 previous occasions, and on each of those 20 previous occasions been before a court and heard strong indications that hitting household members is wrong, would that 10-year-old have capacity to know that they ought not to be hitting anyone else? If the answer is yes, then if all other matters are proved, they will be able to be held criminally responsible. Our amendment reflects modern understandings of repeated offending and is based on 126 years of tested and proven law. In Queensland, patterns of prior conduct can be used as evidence that a child knew their actions were wrong. The government's bill does not sufficiently empower police or courts to rely on repeat behaviour as a strong indicator of criminal responsibility. Practically, this means that in New South Wales, even recidivist youth offenders will continue to be able to exploit the presumption. I repeat, this helps no one, certainly not the community, but it is also not in the best interest of the young offender to be allowed to consistently offend and consistently be excused and run the risk of escalating patterns of criminality unchecked by our law. The law of Dolly Incapax as it stands, and as it is likely to operate under this government's legislation, is not necessarily in the best interests of our young people. It is not always protective to say that children under 14 cannot be criminally responsible. It can make them targets for criminal gangs, using them as mules for contraband and pressuring them to steal cars to order. We see this operating already in parts of Sydney. The opposition is not prepared to empower 21st century Fagans. We want a sensible approach that protects all in the community, including our teenagers. The opposition amendment provides more protection for victims and vulnerable regional communities. It delivers greater accountability for high-risk young offenders, particularly in regional and remote areas where crime rates are disproportionately high. By contrast, the government's bill fails to give regional police and courts the necessary legal tools to interrupt escalating offending early. The government have chosen the wrong test to enshrine in this legislation. And with only a throwaway line in the second reading speech that this will, quote, rectify an inconsistency, the government's bill also takes away the ability for courts to order more than 35 hours of community service, a steep reduction from the current allowed limits of between 100 and 250 hours. This reduction has not been explained, is not justified, and ignores the benefits of community service to preventing future crimes by young offenders. We are opposed to this change. This bill needs significant amendment, which we invite the House to help us achieve in the committee stage.